Yeah, they played all the hits last night. He's like deep down. It wasn't really packed, so I've never been to that venue. So the general admission area on the floor was packed. We did like weird tickets that were like just like seating, and like ours were like in the deluxe area, so it was like kind of the area of it, which is weird because yeah, like it was really nice. There's like a nice like there was food and then there's really built like all these even like a nice thing. The Boeing
Oh, yeah.
that's always
Thank you.
Opening up was pretty good.
All right, everyone, I'm going to call the docket. And so attorneys, if you could make sure if you have someone in custody, bring them out. We're going to start our jury trial if there is a jury trial at 11. Guillermo Constancino is in custody. Stephen Wellbarker. Jonathan Yost is in custody. Laura Romero. Melvin Jones, custody. Thank you. Raymond Ruiz, custody. Jose Lozano. All right, thank you. All right, so today is our jury trial day. So anything that does not work out, we will be in a jury trial, and we have a motion to suppress with you, counsel. And are you all ready to proceed on the motion to suppress?
Yes, Judge.
All right, which case is it?
It's Stephen Wellbacher, but technically it could be under either case. It's the same instance.
Okay, all right.
Just give us one moment.
Sure.
Okay. Your turn. This chair. Counsel on Wellbacher, could someone tell me what the issue is? Is it a stop? Is it a search warrant?
It was a stop, Judge, traffic stop. First issue is extended illegal detention after the stop. And then also the illegal search of the vehicle.
Judge, I'm just gonna pass out.
You may end up breaking a little bit if someone has to take off.
Yeah, I think we said it shouldn't take over an hour, maybe 45 minutes. Do you have a copy of the motion there?
Let me check.
I've got one.
Yes, I do have a copy of it.
I'm already trying to put up the video, which is all the issues.
It's not fine, and this is just a video for the court to see, correct?
Yes, Judge.
All right, so if someone will give me, is there audio on the video or no?
Yes.
We're gonna ask it to be admitted. I don't know if he's gonna say it.
No, I'm just thinking about how I can watch it.
Oh, yeah.
So I was trying to play it up there, but I do have copies on CD as well.
All right, so I'll look at it on CD if everyone is okay with that. I'll see if I can play it from here. And so once you offer it into evidence, I'll see if I can play it.
trying to get this started. It's just
Oh, no problem.
redoing.
Oh, you know, all the, everything updated, I think. Okay, for some reason today feels like a Friday, but I know it's not a Friday.
We're not even halfway through. You gotta make it to lunch to be out there.
That's true. Yes, you may approach. Yes. Jumping in here, if you can make sure that, Mr. Supply for Baines out here, just needs to watch enough for very volunteer, that's. All right, thank you. Oh. So I'm assuming this is in both cases, correct?
Yes, ma'am.
Yes, sir.
All right, are you ready? Court is calling 2023. 0889. CR 0888, State of Texas versus Stephen Wayne Willbacher. Top parties announced for the record for the state.
Daniel Escobar and Lindsay Shaw for the state.
Defense.
Ron Ross for defense. We're ready on our motion to suppress.
Are you Mr. Willbacher?
Yes, ma'am.
All right. Defense, do you have any witnesses to call or no?
Will not have any witnesses, and this is a, without a warrant, a search without a warrant after a stop.
All right, state, do you stipulate that it's a search without a warrant?
Yes, Your Honor, we do.
All right, state, you may proceed.
Your Honor, the state calls Officer Tomlin.
All right, Officer Tomlin.
Yeah, no, I know it worked now. Judge, also just bring to the court's attention, it is starting to work now.
Oh, it's working now?
Yeah.
Okay, thank you. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
I swear.
All right, you can lower your hand if you'll have a seat and state your name for the record. please.
My name is Sergeant Gary Tomlin. Oh,
And you can spell your last name.
Tomblin,
All right, state.
Officer Tomlin, who do you currently work for?
State of Castle Hills.
And how long have you worked for the Castle Hills Police Department?
9 years this May, actually.
And what are your duties with the Castle Hills Police Department?
I couldn't hear. I'm sorry.
What are your duties with the Castle Hills Police Department?
I'm currently on the night shift supervisor.
Okay. Do you ever go out on patrol in the area?
Yes, sir.
Okay. And I'm going to go to September 14th of 2022. Were you working on that night?
I was.
Okay.
I'm sorry, just one.
My mom said, whenever my mom calls, as you all know, I think when moms call, you need to answer.
Absolutely.
You're right, exactly.
All right. All right, you may proceed.
Officer Tomlin, where were you patrolling on that night?
That night I was on the 2100 block of the westbound Fringe Road of 410.
Is that in Bear County?
Yes, sir.
So on that night, did you have to pull someone over?
I did.
What reason did you have to pull them up for?
There was no license plate light on the vehicle.
Okay. And do you remember where roughly you guys stopped after you pulled them over?
We stopped in the the parking lot of Thad Ziegler Glass. So it's at the intersection of the 2200 block of the westbound Fringe Road and the 2200 block of Jackson Keller.
Okay. And when you approached the vehicle, who was driving the vehicle?
The defendant.
Okay. What did you tell the defendant?
I informed him who I was and the reason for the stop.
Okay. Did he ask you anything at that time?
He just stated that he wasn't aware and asked if he could get out to look at the lights.
Okay. And did you allow him to look at the lights?
Not at that time. I had him remain in the car until I could check for warrant status and license status. It's a safety deal.
Okay. So when you went to go check for warrant status and license status, did you see anything?
I saw in his regional database that he has a previous criminal history.
Okay. And at this time, what were your intentions?
For the stop.
Yes, sir.
I was going to issue him a warning.
Okay. When you came back to go speak with him, what did you say?
I let him know that if he wanted to get out of the car to look at the lights, he could.
Okay. And did he get out of his vehicle?
He did.
Okay. When he got out of his vehicle, where did you guys go?
To the rear of his vehicle.
Okay. And while you were at the rear of his vehicle, did you ask him anything further?
Yeah, while he was looking at the lights, I asked him if there was anything illegal in the vehicle. He said that there was not. I asked him if when I asked him that, he said, no, you can take a look. I repeated him. I said, I can take a look. He said, take a look. And so to clarify my intentions, I asked him, I can search your car. And he said, yes.
Okay. So did you immediately search his car at that point?
No.
Okay. Why not?
Safety reasons. Typically we wait for a secondary officer to arrive so that somebody can't attack us from behind while we're looking or run away while we're not paying attention to them.
Okay. And how long did it take for that backup to arrive?
I couldn't tell you the exact amount of time. I'd say no more than 5 to 10 minutes.
Okay. While you were there, did you talk with the defendant?
Yeah, we some small talk. He asked what we were waiting on. I explained to him, since you gave me consent to search the vehicle, I'm waiting for my partner to get here. And just some small talk until Corporal McClellan arrived.
So you mentioned search again.
I did.
And did he say anything at that point?
No, sir.
At any point between when you asked the whole conversation about taking a look and when you mentioned search again, did he ever withdraw consent at that time?
He did not.
Did you end up searching his vehicle?
I did.
And what did you find inside his vehicle?
In the trunk of the vehicle, I located body armor, and based off of his criminal history being a convicted felon, I confirmed inside the carrier that both the front and back carrier had level 3 PACA body armor, soft body armor. And so at that point, I detained him and explained to him that the remaining search was going to be probable cause and that he wasn't allowed to have body armor because of that conviction. He stated that he forgot that he had left it in there after his father's funeral and asked if he was going to get in trouble for it, said that it was a silly reason to get in trouble, and asked me if I could just let it go.
Okay. Did you end up arresting him for that?
I did. I after I finished the remainder of the search, I informed him that he was under arrest for unlawful possession of body armor by a felon.
And at that point, did you do a search of his own person?
I began a search incident to arrest of his person while I was checking his the front breast pocket and right side pant pocket or short pocket. A plastic eyeglass container fell from his waistband onto the ground. Corporal McClellan bent over to pick it up for him. As he was doing so, that's when the defendant said, "There's drugs in there." I asked him what, and he said, "There's drugs in there again. It's methamphetamine."
Okay. And did you open up the eyeglass container?
We did. So at that point, that's when we opened it. And when we opened it, we found 6 individually balls of foil. And that's when he explained to us that each foil contained an 8-ball of methamphetamine.
Okay. So on that night, was your patrol vehicle equipped with dash cam?
It is.
Okay. And are you trained in how to properly operate that?
Yes, sir.
Okay. And then in addition, were you equipped with body worn camera?
Yes, sir.
And are you trained in how to operate that?
I am.
And did either of those devices make a recording that night?
Both of them did. Yes, sir.
Okay. And have you had a chance to view those recordings?
I have.
Your Honor, may I approach?
Yes.
Show you what will be marked as State's Exhibit 1. That's a Coban. You recognize this?
I do.
What is it?
This is the DVD of the dash cam.
And have you had a chance to watch the video that's on that DVD?
I have.
Okay. And is it a true and accurate depiction of what happened on that night?
Yes, sir.
Has it been altered or amended in any way?
No, sir.
Okay, Your Honor, State would offer State's Exhibit 1 into evidence.
Yeah, no objections.
All right, State's Exhibit number 1 is admitted. Without objection.
I'll show you. Oh, this is being marked as State's Exhibit 2. What is this?
That is the footage from my body camera.
Okay. And have you had a chance to view that footage?
I have.
And as far as you're aware, was it a true and accurate depiction of what happened on that night?
Yes, sir.
Has it been altered or amended in any way?
No, sir.
Okay. Your Honor, State would offer State's Exhibit number 2 in evidence.
Yeah, no objections, Judge.
All right, State's Exhibit number 2 is admitted without objection.
Okay. And Judge, permission to publish.
Granted.
There you go. Yes, sir. So Officer Tomlin, what are we seeing right now? This is State's Exhibit number 1.
So this is the intersection of the westbound frontage road of Northwest Loop 410 and West Avenue. It's in the 1900 block.
And what specific lights are you saying that are out?
The 2 license plate lights that are directly underneath the trunk.
And if you want, sir, you can, on that board you're pointing at, you can mark it.
Oh, okay.
You should be able to.
So it's right there and right there.
It's not being marked on my end,
Well,
but I mean, for the court's perspective, he doesn't need to mark. I can view.
just making sure, Judge.
No problem.
So this is as I pull alongside him when I see that the lights are out.
And officer, are those lights being out? Is that a violation of the traffic code?
It is
Do you remember what section?
547.
So from here, I'm going to switch to your body cam video. That is loud. That'll wake you up.
Can I open it? Okay. How you doing, sir? My name is Sergeant Tom. I'm with Kansas Police Department. The reason I'm stopping at your license plate lights are out.
Are you serious?
Yeah.
I didn't know.
Yeah, it happens. That's why it's just one of those little things. You know, like, your license with you?
Yeah, can I look in the, I don't really love.
Yeah, just give me- Yeah, the little lights that light up your plate at
It's not a
night.
great light.
No, it's the license plate lights.
Okay, I didn't have. I didn't think.
Yeah. Where do you work at?
I work downtown.
Downtown? Okay. And then your license is expired, did you know that?
I did not.
Yeah.
Don't tell me this.
It expired back in July, man.
So, let me see. 22, I didn't know.
Yeah.
I didn't have no clue. I mean, I can see.
Well, I mean, not for the light, not for the lights, man. I mean, is that your current address on Richmond?
Yeah.
Okay, and you said you're coming from work?
Yeah, that's crazy. I didn't even know my last 6 5 things. Like, it's been 7 years, hasn't it?
I don't know, yeah, I got issued in 2015.
It's crazy.
Ooh, you right?
Yeah,
Yeah, you're okay. Where do you work at?
downtown with the. Cabin.
Okay. Okay, hang tight for 1 second, okay?
Here, just for the record, I'm gonna fast forward to when you get back out of the car. So I fast forwarded it to the video, it's 5:35.
All right, Steve, come on out, you can take a look. Here's one of those. With that, I know what you're talking about. So these two lights right here, there's a light here and a light here. Yeah, they should be on either side of the camera. Right after you. So, and let me ask you this, man, is there anything illegal in the vehicle? Weapons, narcotics, anything like that? Want to take a look? Like, okay, you can tap this from the car phone. I'm not worried about that. Yeah, that's all right. Cleaner than most of the ones I see. It's got a button. I'm just waiting for my partner to get here real quick and then we'll go. Get this squared away as soon as possible. It's only a couple weeks, so I'll give you a break on that, okay? But get it done. A lot of times you can just, the last time you did you do it online or in person? So you're gonna have to go in person this time then. You can only do it every other time online, so. But like I said, it's only a couple weeks, so I won't give you too much of a hard time on that, man. You get to like, insurance is good, registration is good, all that, so just get those lights fixed. And then, no, it's nothing major, man. It's just those lights, man.
Well, I got accepted from SAPD for improper lane change.
Oh, really?
But he didn't give me an amount. It's like, because it's on the access for the later. He's like, said, it was like, what how fast are they going? And he said, we're speeding. I was like, okay, I don't want to.
And he never told you how much you were going, how fast you were going? Did they tell you when you went to the court? It should be on the ticket. Yeah, take a look. I can show you. When did you get the ticket? Yeah, it should be on the ticket. If they issue the citation, it's supposed to be on there so that you're aware of it. What do we mean? Just my partner, he's right there.
Can we pause for a moment? Why y'all hugged up? What is this? Yeah, how old is he? All right, so, I mean, we don't allow that in the courtroom. Is there a reason he's not in school?
We're here for my husband,
Who's your husband?
Kristen.
Chris who?
Why-
Is that on the docket today? There's no Chris Lind on the docket today.
Your Honor, it's at 11:30 in Judge Naharo's court for bond hearing.
All right, that's Judge Nahara's court. That's not here. Mhm. Why do people think that everybody can homeschool somebody? I consider myself to be highly intelligent, but I would never try to homeschool somebody because now if you're just doing the subject maybe of math, I'm like, I can homeschool. But for all the other subjects, absolutely not. People think teachers are just went to school to be a teacher and they can't teach. Let us homeschool. You know, you don't see anything where it's like a homeschool for doctors. I'm not taken to the hospital. I'm gonna home doctor. Oh, well. All right, we can continue.
You gave me consent to search, and so he's just gonna hang out that way. You can't sneak up behind me and beat me up or nothing. You know, I'm a ginger, I'm breezy, man. Yeah.
So I'm stopping the video. It should be, it's hard to see the time, 8:09. So Officer Tomlin, so we just saw your body worn camera video. How many times did you did you say the word search?
In the total interaction with him twice.
And at any point after you had mentioned search or that you were going to take a look, did he ever say that you weren't allowed to do that?
No, sir.
And I just wanted to ask, if he had said no, what would you have done?
I would have ended the traffic stop.
Okay. Pass the witness.
Officer,
Defense?
just a few questions. After you stopped him and you told him that his lights wasn't working, and I think you said the license plate's light, and he questioned you about that. He said, "Can I get out and look?" And you said, I think said no. Would you then explain to him that it wasn't a tail light and it wasn't a brake light? Because he asked you, was it tail light or brake light? And you said no, it was the license plates, correct?
Yes, sir.
So he asked you to get out, and then you explained what it was, correct? So he knew then what it was
Yes, sir.
by your explanation. Okay. Now, after you went to your car and you checked out his, I guess you checked his license, see if he was a licensed driver, correct?
Yes, sir.
See if he had any warrants.
Yes, sir.
He was clear, correct?
Yes, sir.
So he was a expired license, driver's license, and the license plates, correct?
Yes, sir. The license plate light.
License plates, lights, okay. And you were going to give him warning tickets?
Yes, sir.
When you returned to the car, did you bring a warning ticket with you to give him?
No, sir.
Did you have any reasonable suspicion to continue to detain him at that time?
No, sir.
What was the significance of you putting in your report that you noticed that he had a prior criminal record? What was the significance of you putting that in your report?
Because when I found the body armor, that's how I knew he wasn't allowed to be in possession of it, was from seeing that previous to finding it.
Well, even if you didn't have a previous conviction, you would still not, it'd be illegal to be in possession of body armor, right?
No, sir.
I could have body armor on me.
Yes, sir.
Okay, I'll have to check the law. I'm not sure that's correct, but okay. All right. So, but you didn't know he had body armor at the time that you looked at the on your computer. You didn't know that he had body armor, did you?
No, sir.
Okay, so you returned. You had no reasonable suspicion that anything else was going on. He didn't ask if he could get out of the car and look in. You told him. You said, "Come on out." You went up to him. "Come on out. You can take a look." You told him to come on out. Isn't that correct?
Yes.
Okay. So you detained him. You didn't ask him if he wanted to. You told him to come on out. Correct?
Yes.
And when you asked, "Can I take a look? Do you mind if I take a look?" You asked, didn't you? "Can I take a look?" To that effect.
No.
The video doesn't say, "Do you mind if I take a look?" or "Can I take a look?"
I repeated him when he said, "No, you can take a look." And then I repeated him, "I can take a look."
Okay. And he's saying, "You can take a look." And while he's saying, "You can take a look," you throw out the word "search." We're talking about look, and you throw out the word "search."
Yes.
In no time did you ask him, "Can I search?"
I said, "I can search your car."
We're talking about the initial, when he's out of the car, the first time he's out of the car. You ask him if there's anything illegal in there, and he said no. And you said, I don't know, you mind if I take a look, or "Can I take a look?"
No, sir. I asked him if there's anything illegal. He
Right.
said, "No, go ahead and look." And I said, "I can take a look," repeating him. He said,
Okay.
"Yes." And then I said, "I can search your car."
You did not say "I can take." You said, while he's saying "take a look," you over his words, you said the word "search." He didn't specifically say "go ahead and search," did he? What he told you is you can look.
Yes.
In your mind, do you think "look" means search?
No.
And you, in fact, opened the front door and back door, and you shined your light in there where you could look and see, didn't you?
Yes, I did.
Okay. Okay, so you came back. When you were in your car, I noticed you got on your cell phone and you did some texting. Is that the time you were texting for the backup officers to come?
Don't know.
Well, when did you text, or when did you contact the backup officers you wanted them to come?
When I contacted the dispatcher, I requested another unit.
When was that?
After
After he said you could look?
I believe it was right before I opened the back door.
It's after he said you could look.
Yes,
Okay, and so you had him standing there waiting for your backup officers,
yes,
okay? And you told him, since you gave me consent to search, we're gonna wait for my backup officers. Essentially, that's what you told him, right?
yes, sir.
Okay. When did he give you consent to search?
When I asked, I can search your car.
When did you ask that?
When we were talking by the tail light, by the license plate light.
No. Can I look? And he said, yes, go ahead and look.
And that's why I clarified my intention. I can search your car.
No, I think you just got through testifying. In fact, you did not say, can I search? You said, can I look?
I
And
said,
you threw
"I
out the
can
word
your
search.
car." I used the phrase, I can search your car. And he said, yes.
I think the judge can look at the video and see. I think in fact, you said, look. And when he's saying you can look, then you just threw out the word search. You don't even know whether you heard the word search because he's in the process of talking about looking. Is that fair? Is that a fair? You don't agree with that?
No, sir, I do not.
Okay, so your testimony is he actually gave you consent to search.
Yes, sir.
Okay, so it's all going to go back to those words whenever you said that, okay? Okay, now you searched the passenger compartment, the front seat and back seat.
I did.
Did you find anything?
No, sir.
Okay, at that time, did you have any reasonable suspicion that anything was going on?
No, sir.
He wasn't under arrest, was he?
No, sir.
How did you happen to get into the back trunk? Does it have a key or does it have a something you press a button to open the back trunk?
I believe I used the manual.
From the inside, you were able to open it.
I believe so, yes.
Okay. Did you have a warrant that you could search the trunk?
No, sir.
You weren't doing an inventory search, were you?
No, sir.
And we have a disagreement. My understanding is he gave you permission to look. You're testifying to this court that you said, can I search? Whichever way it was, you considered the search that included to open the trunk up, the locked trunk, and to go into that. You concluded that was your right to do that?
Yes, sir.
It was after you opened the trunk and you found this body armor that you arrested him. Is that correct?
First, I informed him that he was being detained so that I can finish the remainder of the search. And after I finished the remainder of the search is when I informed him he was under arrest for the body armor.
Okay, well, he in fact was under arrest, wasn't he? I mean, he wasn't going to go anyplace, was he, with the body armor? So he wasn't going to go anyplace, was he?
He was detained at that point.
Yeah, okay, that's the same thing. I mean, essentially he's under arrest, right? Not handcuffs, but he's under arrest. He's not going to go anyplace.
No, he was placed in handcuffs. He was detained in handcuffs.
Okay, that's all I have. Pass the witness.
State.
Judge, just real brief, just to clarify.
Here's one of those. What's that? So these people like right here, there's a light here and a light here. Yeah, this should be on either side of the camera. Right, I appreciate that. And let me ask you this, man, is there anything illegal in the vehicle? No weapons, narcotics, anything like that? Want to take a look? Like search it, okay. Hang tight, let's find the car phone.
So he said, go ahead, take a look, right?
Yes,
And then you said, I can take a look.
yes,
And then you said, I can search.
yes.
And at any point did he say no?
No, sir.
Nothing further from
So let
state.
me ask you, you heard that. I guess you're going to disagree with what I saw. I saw you ask, do you mind if I take a look or can I take a look? And while he's saying, go ahead, then you threw out very quickly, I didn't hear, do you mind if I search? All I heard was the word search. Like you're clarifying the word look, you're clarifying the word search, but he's already in the process of answering, go ahead and take a look. And your testimony that he actually told you to go ahead and search?
Yes,
And so it's his obligation. Let's say if it was, well, if he did not have a right to search, say you didn't, after we were waiting for your backup and you said, you gave me a right to search, it'd be your opinion. He's got to say, don't search. If he had never given you the consent in the first place, he's got to say, don't do it.
Can you clarify your question? I don't know.
I'll withdraw it. I think it's a little confusing. I'll withdraw. Judge, that's all I have.
Nothing from the state, Judge.
All right, is this witness excused or subject for recall?
Excuse from the state.
No, he's excused.
All right, thank you.
Thank you, ma'am.
All right, state, any further witnesses?
No, Judge.
Defense?
No witnesses, Judge.
All right, the court will hear argument. State?
Would it be defense first, Judge, because it's their motion, or is it us first?
All right, well, whoever wants to go first,
go first,
I
Judge.
will hear from either side.
Judge, I think it's clear it's a traffic stop. It's not moving violations. I think the duty under the present law is he's got to give a ticket and send him on his way unless he's got reasonable suspicion that something else is going on. He testified he had no reasonable suspicion anything else was going on. As soon as he did the computer check in his car, he had a responsibility to send him on his way. Anything else is illegal detention. My
Right,
guy
so-
didn't ask at that time, can I get out and look?
Okay, so
He told him to get out of the car.
defense. So with regards to your argument, or is your argument that the consent your client gave, the officer went beyond the consent, and it's hinging on the definition of what look means or whether or not he gave him consent to search?
The first argument, it was an illegal detention. After that detention, everything goes.
Okay.
Second argument is there was no consent to search. It was a consent to look. My argument is look is not the same thing as search,
All right, so let's start with your argument of illegal detention.
right?
Why are you saying it's an illegal detention?
He had a responsibility. It was a traffic stop after he cleared he had no warrants. He had a responsibility to give him tickets and send him on his way. And he testified, I was going to give him a warning ticket.
All right, so with regards to the illegal detention, do you think your client giving the officer permission to look does away with the illegal detention or no?
No, I think that once you have an illegal detention, anything else that the officer gets is thrown out. You don't get to do an illegal detention, then start talking and get the guy to say something. Oh, well, now you've admitted to something after we illegally detain you. After you illegally detain, everything else gets thrown out.
But why are you saying he was illegally detained?
Because he had to give him a ticket and send him on his way. Did not have reasonable suspicion to continue to hold him there.
So
And he continued to hold him by telling him to get out of the car.
So your argument is, even if your client, and I've seen the video, even if your client gives consent for the officer to look, it's still illegal detention?
That's right, because he gave the consent later on after the detention's been there and the officer's talking to him. And he did not give consent to search. He gave consent to look.
All right.
And my argument is look is not the same thing as search.
Okay, so what is your argument for what does look mean as opposed to search?
Well, I don't have the Webster's.
No. I'm just trying to hear your argument so I can make a decision. So I'm not looking for Webster's dictionary. I'm assuming that you're going to say search doesn't mean looking in the trunk.
It doesn't mean.
I'm sorry, look doesn't mean
Look
searching.
does not mean the trunk. It does not mean looking in containers or opening the glove compartment or looking under the seat. Take your flashlight in there and look. We can't have the officers now substituting the word look for search. We're going to have that going on all the time. It's not clear to the individual that you're stopping what their intent is, what they want to do, what they're asking them. So yes, I think that he did not give consent to search. He gave consent to look only.
Okay.
And that would be the passenger compartment. The trunk, you got to have a warrant for the trunk, something that's locked. Or you got to be doing an inventory search. And it was an inventory search. There was nothing going on. He had no reasonable suspicion when he opened the trunk to even go into the trunk.
All right, so your argument is that one, look and search means something completely different. Let me ask you if, and this is just hypothetical,
Right.
you know, I will watch states exhibits 1 and 2 to make sure that I've heard everything correctly. But if your client had given a consent to search, then would it have been okay for the officer to look in the trunk or no?
I would say no, it wasn't qualified to say no in the trunk, and I don't even think he had that would not have been all right to even look in the passenger compartment because of illegal detention in the first place.
Okay.
The illegal detention nullifies everything else. You can't fix that by getting him to consent to something later.
Okay. All right, thank you. State?
Judge, just really briefly, so state would argue it's not a illegal detention. Whenever they first interacted, the defendant did say, "Can I take a look?" And the officer said, "No, not at this time," because he had to go run his information and it would have been presumably dangerous to have the defendant out of the vehicle at that point. When he comes back, he says, you can take a look, come with me." He's just showing him what was wrong. Because even after he shows him, the defendant was still confused about what exactly the officer was talking about. It took the officer pointing towards it to show, this is what I'm talking about. So state would argue it's not illegal detention. He's just trying to show him. From there, there is an exchange where the officer asks, is there anything illegal in the vehicle? He's allowed to ask that. The defendant could have easily said, no, there's not. And he could have just stopped there. At that point, the officer has no other reason to detain the defendant. He would have been on his way. Instead, what the defendant says is, you can take a look. The officer asks and repeats those words back to him and does mention search. At that point, the defendant does not say anything. He does not say, I only said you could look, or no, you can't. He doesn't say anything around that area. That would fall under the good faith exception. The officer believed that he had the consent at that point once he used the word search, and the defendant had the ability to say no. The officer further even asked again or mentioned again the search in regards to his partner being on the way. Again, the defendant had an opportunity at that point to say, no, you cannot search, or I only said you could look. All of those things could have come into play. And the defendant said nothing at that point. State would argue that the defendant gave consent to search the vehicle and that the officer had a good faith, even if it turns out that he didn't give consent, the officer had the good faith exception to be able to say he was under the belief that there was consent and that what he was doing was okay. So the state would argue that, again, it's not an illegal detention and that the defendant gave consent. And from the officer's perspective, under the good faith exception, he had the ability to still search because he believed and had a good faith belief that he was able to conduct this search.
All right.
Could I?
Oh, no, defense, you'll have final argument.
Judge Miranda, let's go to Miranda. You don't get to start asking a guy questions. You arrest him, get to ask him questions. If you start asking him questions without Mirandizing, thrown out, he doesn't have to say, I don't want to answer. You got to ask him questions. You got to talk to him. You got to give him his rights. The search, it's not his responsibility to say you can't search. It's the officer's job to get the consent. The consent has to be knowingly and intellectually and clearly made known that it's consent. He didn't do that. The word search was thrown muddled in some other words. The question was, can I look?
All right, so I just want to be clear. So both parties are saying that the stop was valid. The issue is whether or not the detention was valid. Is that correct,
That is
counsel?
correct. Number one. Number two, the search.
Okay. All right, then this is what we'll do. If you all will give me till 1:30, because then hopefully I'll have a break. And at 1:30, I will give you all my decision. All right.
All right.
And if there's, I know the case law on this subject matter and know the penal code on this matter. But if there's anything you all would like to give me before 1:30, you're more than welcome to do so. Okay. All right. Thank you.
Thank you, Judge.
And if I could have states exhibits 1 and 2, and I will review those during the break. Thank you.
You should be able to take one from the thing outside.
Good morning. Hi. All right, so do we know what the issue is with Mr. Guillermo Constantino? All right, so what we'll do is we will reset this. Let me see if we can get Mr. Mauer here, and I'll give him a new date. State Guillermo Constantino is going to be reset. The defendant has been taken to the hospital. So we just need to figure out what's a date where everyone can be here. And this is going to be contested, correct?
I think in the end, it may not be, but
Okay.
we'll see.
All right, so as soon as Mr. Mauer is here, I'll set it for a different date that is agreeable to each party. If you have witnesses here, they can be excused.
Okay, thank you, Your Honor.
Thank you. Constancio. Okay, I'm just adding different letters to everything. Constancio, but I got Guillermo right.
Yes, you did.
Okay. I'm working on it. You know what my problem was? I was thinking about what do you call it? Conquistadors. But I tell you, now I'm gonna remember that. Hello.
Judge,
Yes.
maybe to reopen the argument or just additionally said anything else. I've been made aware, I don't have a site that there is a case law that says that unless the license plate is obscured, the license plate's light not operational is not reasonable suspicion to stop a vehicle.
All right, so we will,
If that in fact is the case, then it would have been illegal stop from the onset.
okay,
I don't know if you have that case or.
I will look for
I
that
don't
case.
have anything to check that out. Well, right now, so.
Judge, state law for this time, it's section 547.322 of the traffic code. That's the tail end.
No, I've seen that. What you're saying is not necessarily in the traffic code. So if there is some case law that's out there, then I will review that. But it appears that to the court that the stop was a valid stop.
That's what I thought too, but I've been surprised that there.
No. I always accept more argument. So we'll be back in the afternoon, and I'll see if I can find if there's any case law that says that. Then if there's case law that says that, then we're in a completely different place.
Thank you.
Six to confirm. Just. Just the camera down? Yeah, everything.
Okay, Deputy Laura, I think I'm going to pick us up some turkey sandwiches. The turkey was great, and I don't even like turkey really,
4 to 8.
but I think because it's smoked or something. Yeah. You're here on Jose Lozano? All right, so just give us a moment. The jury's going to be up here at 11, so we'll see where we are, because there are cases that are before yours.
If I can be excused till just before 11.
Yes, thank you.
Can I talk to him over here? Thank you.
Sure. Hi. And Caroline, I know that Norma is out with her mother. Could you let her know
that. She doesn't have to come in today unless she just wants to come in today.
All right, thank you.
I mean,
Hi, your client is in the hospital,
Yeah, that's what they told me.
so I'm wondering, what's a date that we can call it back, Travis?
Yes.
So we'll still put it on the contested docket,
Okay.
but I don't know what your schedule is.
Hey, I'm out of town tomorrow and Friday. Tuesday, I'm in Hondo and
Well, I don't know the reason for why he's at the hospital, so I'm thinking at least 3 weeks, so we can see.
I'm not going anywhere.
Okay,
I've been a fugitive for 3 years. It's not gonna. Couple
All
weeks
right.
is not gonna make a difference.
so are you all okay with doing it the week of June 5th?
I am.
No objections.
All right, so we'll do it Wednesday, the 7th at
Okay.
9 a.m. Caroline, is there anything else I have on Wednesday, the 7th? Other than we will probably be in a jury trial? How long do you all expect?
Hours and hours.
Okay, see, Robert always says that, and then I've seen him in trials, so he doesn't ask unnecessary questions.
I gotta make something up here.
All
Oh,
right.
I'm sorry, was that out loud?
Yeah.
Inside voice.
Okay.
Inside voice.
So we'll do it Wednesday at night. How many witnesses?
I think the state would only really just prove up the technicals with the.
All right.
supervision.
So we'll do Wednesday on June 7th at 9 a.m.
I will be here.
Thank you, everybody.
All right, and if it turns out it is not contested, just let me know.
Okay.
And if it's not, Mr. Mauer, if it turns out it's not contested, then we'll move it to a different day.
It's just state's being really cantankerous, so I don't know. Do what I can, but
You know me, Your Honor.
All right.
so much anger in the room.
All right, and Mr. Porter, on your case, if it's going, is it going to trial?
It is, Your Honor.
All right, and so if, I'm not saying he will be convicted, nobody knows, but if he were found guilty, punishment, where would he go?
To the court.
Okay. All right, so we'll start jury selection then with your client at 11. Oh, Dinah, I searched for you on Bridge and I couldn't find it to pull up what you've given me. Because you have room 5, correct? And so I went to room 5 and there's no May 17th. Not 17, May 23. The May 17, 2023, it comes back for Hobson, somebody named Hobson.
Let me shut down.
All right, thank you. And I need to talk to you about two emails you sent to me. Okay, look at this. We both need to talk to each other, having a conversation. All right, just give me a moment while I sign these vouchers. Room 8. Okay. Will the passwords still be the same? Okay. I do not see it in room 8. Oh, wait, I found it. You're gonna be like, no. Yes, I see. Oh, no problem. Yeah, no, that's fine. Oops. That's okay. Caroline. So on the first two, these need to go to the voucher committee. And this one, I've signed it, and the MAC needs to be signed. Okay. All right, is there something to take up on Mr. Jones?
I'm sorry, Judge.
Anything to take up on Mr. Jones before the jury?
Judge, I'm gonna. Yours. Use my words. Well,
You can't just point towards me.
Please join me.
Yes, thank you.
I filed a motion in limine yesterday, Judge. I'm
Mhm.
gonna move forwardly because I left two things off of that. I already talked to the state about it. He's in agreement with it.
Okay,
Those two things are that the car was reported stolen during a sexual assault. So the sexual assault is not going to be there. And also the mention of cocaine. Just to let the court know that it was never tested, it was never charged with it.
okay. All right. And then the case that we're proceeding on is the 2022 8529.
Yes, Judge.
Okay.
At 11 o'clock.
Okay, thanks.
11 o'clock.
I'm sorry?
11 o'clock.
Yes, 11. All right, and Vashon, you needed to speak with me? All right, can you mute us, please? And then when you come around, I'll show you what I'm talking
Hey, what's up, buddy? What do you mean?
Deputy Mejia, who are the people who are waiting here? People here?
You're with him, right? Yes.
Okay,
And the other person is Mr. Young's, we're waiting for Mr.
Yeah, I got
Young's.
that.
all right.
I got it.
So if you could, do you have Mr. Cox's number?
Yes, ma'am.
If you could call him and tell him that we're starting jury trial at 11 and he needs to be here.
Yes,
There's
ma'am.
another case that we're starting on first because he's been in custody longer, but if you could have him come here.
Text him and
All right, thank you so much. Good seeing you.
Okay, that's no problem. I just need to make sure, I want to get you all from you. Okay. Okay. Yeah, I see. Yeah, I'll get it together. Working. I got it.
Yes. No. Well, I'm always busy, but what do you need? Sure. How are you doing this morning? Oh, I'm sorry. Well, even though you're under the weather, I appreciate you coming in with the mask because you're under the weather, protecting everyone. There you are. All right, you're welcome. State on Melvin Jones, are you all proceeding on both counts?
No, Judge, I discussed it with Mr. Porter. We were gonna wait and abandon the UUMD.
Okay, all right, thank you. No. Okay. All right. Oh, I'll do it. I can stop video. Okay. You're welcome. And since they're going to me for punishment, we may just end up only doing jury selection today. Then we'll have all day Friday. State. We're just gonna do jury selection today. I said, we're just gonna do jury selection today. Yes, because I think, well, do you have witnesses here?
No,
No, they're not yet.
yeah, not yet.
I mean.
All right, let me see then how long this jury selection is gonna take. If we finish before the afternoon. Of course, we'll take a lunch break. And then depending on your witnesses, because I don't like for a witness to testify and then the defense or the state doesn't get a chance to cross-examine. So we'll see where we are. All right. And I have these, so I'm just going to look at them. Okay. And you can.
She's currently set for May the 30th. On my motion is, I don't know if it's there in the file, Judge. I'm asking I'm taking some time. I'm having my first child, so.
Okay, you're whispering.
I'm sorry, I'm having my first child and I'll be out from May 29th to June 16th.
Oh, you're having a baby.
Yeah, well, not me, but
I mean,
I'm in support.
So are you going to be in the delivery room?
Yes, that's.
Are you going to pass out? Or are you going to be there to help?
I've actually crowdsourced the whole thing, and I don't know. I don't know the answer to that.
You don't know if you're going to pass out. I don't know. Maybe it'll be a distraction.
But she, I called Ms. Romero. I think we had this set yesterday, so she couldn't be here today. She maybe could be here tomorrow or Friday, just to, she's willing to come in for that, or perhaps by Zoom if the court would allow. But I just wanted to make sure the court knew that she wasn't not here for any other reason than I just got a hold of her this morning.
All right, state, he's having his first child and he wants to be at the delivery, then he's taking.
To the 16th, so she's due on June 2nd. So I'm taking the 30th through the 16th.
So are you going to object to the motion for continuance?
Your Honor, the state will hold off on any objections.
See, he started his sentence and you thought, is he going to deny me? What's going on?
Already it's just so ripe with joy, but a lot of terror as well. So
Well, that is awesome. Do you know if it's going to be a boy or girl?
maybe a girl.
Oh, are you naming her Stephanie?
Well, no, it's like I was intending to say something about the name, but my wife is adamant. She said, no, you're not saying the name until she's here. I'm doing that announcement. I was like, okay.
All right, so you need to start, just mentioning Stephanie over and over, or either Vashon.
It'd be a pretty middle name for this one, Judge, not, no disrespect, but I think that she has her heart set on the name, so.
Oh, that's going to be awesome though.
Very excited.
All right, so what date do you want this called back?
I intend to be back, or at least this is through June 16th. Any other day after that, Your Honor, I'm available.
All right, so what we'll do is we will put this, let me look. We'll put it on June 20th.
Yes, ma'am. Thank you.
And will you let your client know?
I will, absolutely. Yes, ma'am. Thank you for
All right, thank you. Enjoy. Have a great time.
ma'am. Thank you. Thank you so much. I really appreciate it.
Sure. All right, thank you.
And actually, I'm with you. I just have a case that I.
Yeah, there's lack of soul. Is it associated with this? Is it associated with this? Okay, well,
Yes, sir.
And Caroline, this one is gonna be reset for June 20th.
Yeah, I mean. Unless it's supposed to get in. One thing. Probably that's some of the- Yeah. Oh, well, yeah. You know, I don't have. It is. So.
Yeah.
Frankly, I would not. I like that. I think it's, the report should be overall. That's the reason. It should be. Well, I don't know about that. Yeah, at least I'll know where to look. It's such word that they go to also there's nothing on there. So they don't really follow it. That would be good. If I go. Who's in charge of this? Technically, it's not always happening. That's the reason I can find it. Yeah. But, yeah, but, let me get that, that other stuff together. It's interesting, your average trial record is about. Yeah. 200 pages. I mean, as long as your transcripts. So if you have last time for trial. Oh, okay, well, are they? You mean like what? Oh, okay. Very switch forward. No, I don't. All right, yeah, just let me know. Yeah, I can do a third. If they really want to do, you know, because we could always, I could always just like say, hey, well, I think for those tickets or something like that. It is, one of my exhibits has very small text, so I'm going to go less. I have to relative. It's great too. It's got like much to. And you know, when you do such pieces, it's very common. Okay, all right. All right, what you're saying. Oh, that. I need to, always the wall.
Is this? All right, could I see the parties on Raymond Ruiz? There's a plea to 2 cases. And Bashan, there's no application. All right, thank you.
Speak up loud so she can hear you, so. She can only talk down one person at a time.
Court is calling 2023 CR 0295 and 2023 CR 0293, State of Texas versus Raymond Ruiz. Can I have parties announced for the record for the state?
Lindsay Shaw for the state.
Defense?
Armando Horta, representing one case, Your Honor, representing Mr. Ruiz, Your Honor.
All right,
I'm William Davidson. I represent him on most of his cases.
right. And are you Mr. Raymond Ruiz?
Yes, ma'am.
Counsels, in each of the cause numbers, have you received all the discovery and did you review that with your attorney? I'm sorry, with your client?
Judge, I don't have, I mean, mine is being dismissed, so I don't know.
No. All right.
Yes, Your Honor.
All right, and then the counsel whose cases are being dismissed, did you review the discovery with him?
Yes, Your Honor.
All right. Mr. Ruiz, in each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment in each of the cause numbers?
Yes, Your Honor.
State and cause number ending in 0295. Are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the habitual enhancements.
Any objection?
No objection from your honor.
No objections, Your Honor.
And in the cause number ending in 0293, are you proceeding on the indictment as presented?
No, Your Honor, we're also waiving the habitual enhancements. as well.
Any objection?
No, Your Honor.
No, your honor, William Davis.
Mr. Ruiz, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those with your attorneys? Did you understand them? And did you sign them in all the appropriate places?
Right.
And each cause, you're charged with the offense of assault on a peace officer, judge bodily injury as a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that by entering the pleas in these causes, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these causes?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor. I might be correct.
Yes, your honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offenses?
Yes, Your Honor.
Yes.
Mr. Ruiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
Oh, ma'am.
Has anyone promised you anything other than the plea?
Oh, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
And are you a U.S. citizen? Then in each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, I'm going to show you the plea bargain page. Did you review that page with your attorneys? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, in each case, punishments to be assessed at 6 years in the prison. There are no applications. The cases were run concurrently, and the cause numbers being taken in consideration are 689, 4525, 695, 7005000, 2023 CR 0294. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
There's also another case
That's
that has.
being dismissed outside of the pleasing.
I'm William Davis.
TIC
Yes,
actions.
I understand. I'm William Davidson, just for the purpose of the record. As informed yesterday, there was a sealed case against my client. The state has told me today it's going to be dismissed,
Okay,
not in the paperwork.
all right. Next, I'm going to show you in each cause number what is entitled waiver of appeal paragraph. Did you review that paragraph with your attorneys? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsels, have there been any such motions in either cause number?
No, Your Honor.
No, your honor.
All right, then the cause number ended in 0295. How do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ended in 0293. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's
In
plea.
each cause, the state offers State's Exhibit 1 and all attacks.
Your honor, I've been over it with my client and William Davidson, and he says he understands all of it.
We have no objections, Your Honor.
All right, state, you may continue to confer. Mr. Ruiz, in each cause number, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor. Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, just ask the court to accept the plea bargain agreement that we have with the state. This is William Davidson, Your Honor, and I asked the court to go along with the plea, but I also wanted to put on the record that last night I e-filed 3 motions for continuances on my cases. I'm asking the court to disregard these in lieu of this plea. I was going to argue to the court certain criteria my client had brought up, but this plea makes all that moot. And my client wants to go ahead with this plea. And so I'm just asking the court to agree with the plea.
All right, and cause number 2023 CR 0293, court will follow your agreement, sentence you to 6 years in the prison, give you credit for any time served. This is run concurrent with 2023 CR 0293. County Court, taking consideration County Court cause number 684525695189700 2023 CR 0294. And just one moment. And there's to be no contact with Elizabeth Mateos, Mateos. And in clause number 2023 CR 0295, the court is going to sentence you to 6 years in the prison, give you credit for any time served. This will run concurrent with 2023 CR 0293. Taking consideration County Court Cause number 6894525, 695-189, 2023 CR 0294, County Court Cause number 700500, and there's to be no contact with Elizabeth Mateos. Is there anything else from either side with regards to sentencing?
No, Your Honor. Yeah, I just wanted to put one thing on the record to make sure that it's clear that I talked to my client about this. I met him in federal court. He was released from federal court to deal with this case. My understanding, once he does the state time, he's got to go back to the federal prison. I just wanted to put that on the record.
Okay,
Nothing else, Your Honor.
all right, thank you. And each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
And each cause number, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And in each cause number, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or an ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you?
43.
All right, you're going to have to make some changes in your ways. Otherwise, you're going to find yourself in and out of prison. And that's where the majority of your life will be spent. You're going to look up, your life is going to be over. If you continue the way you are, you're going to end up in federal custody, end up in state custody, and end up in somebody's jail. You understand? Now, I am serious. When I ordered that you to have no contact with Elizabeth, you are not to have contact with her. Do you understand?
Yes, ma'am.
She does not want you anymore. She does not love you anymore. Well, maybe she still loves you, but you all should not be together because that's not a good pairing. Do you understand?
Yes, ma'am.
So you are to have no contact with her. All right.
Yes, ma'am.
All right. Good luck to you.
Your Honor, I'm sorry. Can I just add one thing? Can you
Sure.
Come back, please. I'm sorry.
Excuse me. Mr. Davidson wants to add one thing. Yes.
Yes. Your Honor, I understand that you made a no contact order with one of the alleged victims. However, on the case dismissed, there is another alleged victim. I'm assuming the court has no intent to issue a no contact order in that.
Who are the complainants in the other case?
I think that's your case. I'm not.
That case was dismissed, Your Honor.
All right. This is the aggravated assault.
It's a case 7154
All right. Just one moment.
22.
We're on the record. There's also to be no contact with Lisa Gonzalez. And that's Lisa, and that's Gonzalez with an S. And there is also to be no contact with I've already stated Elizabeth Mateos. So state if you can please let the complainants know in those cases that the defendant is not to have any contact with them. And they have the ability to not accept phone calls from the jail. So if you make contact with them, there's going to be issues. There's going to be issues with your parole. There's going to be issues with whatever is happening in federal court. Do you understand? All right. Thank you.
Thank you, Your Honor.
Thank you, counsel.
No problem.
All right, Mr. Yost, is Mr. Yost out here? All right, come forward. And then we're bringing the jurors out in a moment. All right, and I don't have time to hear the bond issue. So we'll have we'll have Judge Nahara hear the bond issue. And Caroline, if you could send an email to Judge Nahara and ask him if he's available to hear the bond issue. So Mr. Nahara will hear that. With regards to the motion to revoke,
To withdraw.
I'm sorry, the motion to withdraw. Thank you, counsel. Yes,
On that motion, Judge.
we're not on the record yet. I'm just trying to figure out what the issue is.
Well, what happened is that I hadn't had an opportunity to see my client for, I guess it's over close to maybe a year.
Oh, well, you can see him now, Mr. Cox.
So in terms of defending someone I can't communicate with, that put me at a disadvantage. So since he's here now, I would like an opportunity to confer with him and just hold that in abeyance, Judge, if you can.
All right. So, Mr. Cox, what I can tell you, if the issue of your motion to withdraw is you haven't had contact with him because nobody's seen him because he hasn't shown up for his court dates when he was supposed to. Mr. Yost,
Yes, ma'am.
if you don't see your attorney, that's your fault. We're adults here.
Mm.
And so this is going to jury trial. And when it goes to jury trial, guess what? If you have not spoken to your attorney because you are not where you're supposed to be, then that's your fault. You will be going to a jury trial with an attorney that you have not spoken to. Do you understand?
Yeah, may I say something?
No, I don't think your attorney wants you to. Mr. Cox, do you want him to say something?
I don't know whether it'd be in his best interest at this time, Judge, if he,
It's probably not.
all right, well, give me an opportunity to confer with him, Judge, and then if I need to urge something, I'll have that talk.
Then what we'll do is,
We're not gonna set a
state-
date right now.
you know, we're going to come back tomorrow on Mr. Yost. And I will be the person to hear your bond motion tomorrow.
I haven't filed a motion. Well, my motion is really just that I be involved when his bond is set. So
Oh,
it's not like a motion really to do anything, but at least.
oh, no, everyone will tell you here when there's a hearing on a bond, I always require that parties confer.
Oh, okay, so it's.
Yes,
it's
so
not
there
like
would
a-
not be a
It's
surprise.
not a motion really for his bond to do anything except just to.
Because I think he's remanded without at this point, Judge.
Yes, he
and I
is.
think he's entitled.
Well, we can take that matter up.
To, I think he's entitled to a bond.
Oh,
That's right. And if he is, then I just wanted to be able to provide the court some exhibits to consider in setting the bond. That's all.
we will take that matter up tomorrow.
Yes, ma'am.
So, Mr. Cox, if you would like. Yeah, disregard. Thank you. What we will do then is we'll recall him back for tomorrow. And Mr. Cox,
Yes, ma'am.
Deputy Laura, do you know if the courtroom is next door? If you would like to confer with him next door, we could probably make that arrangements.
If they're,
I'm not sure. what
We're not
the
sure.
names are, we have to check.
if they are, if not, then I'll come back and do it early tomorrow.
All right.
But I'll try.
We'll see if there's available. If not, we will most definitely have him back tomorrow. So if you will remain,
Yes,
and
ma'am.
we'll see if next door is available for you.
Okay, that's fine.
Are we going to have the bond, you'd have the bond set before we get a trial date?
If you all want a hearing on that, just file motions and I will hear it. If you state if you're waiving notice, defense, if you want to do an oral motion for a bond, you can do that tomorrow. It's just that we're starting a jury trial right
Oh,
now.
no, I want to be here for the bond hearing. I just want to make sure that we're not getting a trial date yet. This case requires 2A letters and flying in witnesses, and so I just wanted to make sure that I got a little bit of.
Oh, no, that will be taken care of tomorrow. We're not going to start a jury trial tomorrow because we're going to be in a
Oh,
jury trial
okay, I
now.
thought you've been jury trial for this.
Yeah. I mean, if you all want a jury trial tomorrow, we will do it. We will have two juries working at once.
Maybe we do it tomorrow.
We just finished a jury trial, so we're ready for another one.
Okay. Great, thank you, Your Honor. I'll see you
All
tomorrow.
right, thank you.
I'll stick around.
All right, so we'll come back tomorrow.
Okay.
Thank you, Deputy Lawrence. State, is this one witness rule thing that we're doing? All right, thank you.
We're doing a 3 witness only.
Okay. You know, I always tell the state, if you're doing one witness rule and it's a murder case, who are you calling? Is it the person?
victim.
Yeah. So I'm like,
Not back there. Where you could possibly sit in that chair at the end. That, the front, you can sit there. She wants to monitor the Bedard judge.
okay, sure. You can sit in the chair. You're welcome.
I'm not in charge. You can sit that over here.
All right, does anybody want a time announcement? Because each side said 45 minutes.
Probably 5 minutes left.
Okay,
Yeah, I've got, I'm gonna do nothing.
thank you, Mr. Porter.
I can't take that.
And I'd say that just simply because unless they're talking away. They're talking away.
You know what my mom calls me and says? She's like, there should be 2 questions asked on voir dire. 1, can you be fair? And 2, do you have common sense? And then she's like, that's it.
The problem with that logic is this. You ask them if they're gonna be fair, everybody's gonna say yes.
Yeah.
I'm a fair
Okay,
person.
you can tell my mom that.
I'm a fair person, right?
Yes. Impact.
We did.
It's in the basement and you know, they gave him a courtroom that's really a closet. And they said, let's put a restroom in it. So then we can, you know, sort of like in New York, let's just put a restroom there. So now we can sell it.
Trying to get it to like the box.
All right, let me see if I can find it.
All right.
I'll Google it.
You're gonna do a Google search.
I'll Google search.
Okay. Probably.
Okay, so we can. I'm setting up mics.
No problem. Yes. Sorry. Oh, but you need us. And Deputy Mejia, are they lined up? Okay. All right, and just so everyone knows, I always do alternates, but please do not tell them the alternates. And the other thing, guys, if you cannot tell them people who are in or not in the splash zone, because then the people who are not in the splash zone, they just ignore everything. And they tend to get a little bit upset, like, why did y'all call us? And the charge in this case is possession of a controlled substance. Penalty group 1, 4 grams to 200 grams. Is that correct?
Yes, Judge.
Okay.
That's count one, or count two.
They've informed me that they informed you that they were waiving count 2.
Okay.
And we'll put that on the record. Oh, we need to go on the record now. Sorry. Court is calling 2022 CR 8529, State of Texas versus Melvin Todd Jones. Can I have parties announced for the record for the state?
Daniel Escobar and Lindsay Shaw for the state.
Robert Porter from Mr. Jones.
All right. And are you Mr. Jones?
Yes.
Right. So are we proceeding on the indictment as presented, state?
Judge, state's going to waive, I believe it's count 2 to you on state.
Any objection?
No objection, Your Honor.
All right, then count 2 is waived. And defense, have you received all the discovery?
I have.
All right, and did you review that discovery with your client? Court will find that the state is in compliance with discovery, and then we will bring the jury in. And I will do a short voir dire, and I'll release them for lunch, and then we'll come back at 1:30.
And Judge, just so I can tell our witnesses, are we going to go into testimony, or do you anticipate if we're going to create that time just for today?
Well, Mr. Porter is telling me that his voir dire should not take that long. So at least have one witness available.
Okay.
And we'll see where we are.
Ready, Your Honor?
Yes, we're ready.
Sure. All of my parties?
All right, so jury. Yes, sir.
Number 1, there. Number 8. Number 8, give a nice row.
Yes. Okay.
Number 60, leave the next row.
Oh, please be seated. We're standing for you all. Unless y'all are just standing because you want to exercise and look around or. Yes, I'll just keep it on my butt now.
Next row.
Let's go.
37. 36, 37. 43.
And my hips.
Nine.
All right, thank you, everyone. Please be seated.
Your Honor, number 44, she has a very raspy voice. You may not hear her.
Okay, all right, thank you. All right, good afternoon, everyone. And I say afternoon because we're so close to 12, you can count it as afternoon. But I will say that response was very weak. Good afternoon, everyone.
Good afternoon, ma'am.
Oh, that is awesome. All right, you are in the 187th District Court. I'm Judge Stephanie Boyd. You are on the 4th floor and you're in the 187th District Court. So where are we? Oh, now everybody's trailing off like you're singing Old Lang Syne. When people sing that, you know, you have the first bar, then everybody starts trailing off. So I'm gonna repeat it again. You are in the 187th District Court. You're on the 4th floor and the judge is Stephanie Boyd. So which court are you in?
187.
All right, what floor?
Stephanie Boyd.
And who's the judge?
Stephanie Boyd.
Now I know what you're asking yourself. You're probably thinking, I already know where I am. Why is she asking me this? And the reason why I'm asking you this is so that you can remember, because sometimes we're going to take breaks. And when we take breaks, everyone has to leave the courtroom. And then you have to come back. And sometimes when people leave the courtroom, they say, I want to take a restroom break. And then people end up getting lost. We've had people before who end up going to another jury and we're looking for them and they're in another courtroom. And we're like, you're not supposed to be here. You're supposed to be with us. And then we had some people who will say, I looked up and everybody was gone. I didn't know where I was supposed to be. So when we take our breaks, if you ever get lost, if you remember the 187 District Court, somebody will be able to tell you where that is. Or if you remember Stephanie Boyd, because I'm the only Judge Boyd in the entire courthouse, okay? So to my left is the court reporter. Can you raise your hand? I always, when I can, try to make everybody's job as easy as possible, because the many jobs I had, I would always say, sometimes it's never the job, it's the people. So I always try to make people's job as easy as possible. So the court reporter is taking down everything that everybody says, and that's her job, to take down everything. And if you can imagine the number of people we have here, and you are new to her, some of the attorneys are new to her, and everybody speaks at a different pace, and she has to get familiar with that so she can take it down. If you whisper, she cannot hear. And for court reporters, when people are reading their records and they see an audible, that doesn't look good for them, because then people will say, you're not a good court reporter because we have too many inaudibles. So I always try to make it so that her court reporting will never have an audible in it. So you all have cards in your possession. They are very expensive cards. Can everyone raise your card and keep it held up for me? Don't lower it until I instruct you to lower it. All right. So the people in the box, lower your card, please. The people on this front row, please lower your card. Everyone else, nope, just the people on this front row are going to lower their cards. Everyone else, keep your card up. All right. Yes, keep your card raised. If your card is still raised, to make the court reporter's job easier, whenever you respond to a question, if you can, please stand, because she'll be able to hear it, because the acoustics are not good in this courtroom. So will everyone be able to do that for me?
Yes, ma'am.
All right, you can lower your cards. Now, I will tell you, if you all are able to do this, you will be the first jury panel that we have ever had who have been able to follow that instruction. So I have faith that you all will be able to do that. So the next thing I'm going to have is I'm going to have the parties introduce themselves to you for the state.
Daniel Escobar.
Good morning, I'm Lindsay Shaw.
For the defense.
Good morning, ladies and gentlemen. I'm Robert Porter. This is Mrs. Fitzsimon. She's going to be assisting me today. And of course, this is Mr. Melvin Jones.
All right. So is there anyone here who recognizes any of the parties who just introduced themselves to you? Okay. Now, this is a criminal court, and the case that you will be hearing today, if you are on the jury, will be a case that's a possession of a controlled substance, 400 to 200 grams. And we'll talk about that some more. What I want you to know is when any of the attorneys speak to you, they're talking to you about hypotheticals. They are not allowed to talk to you about what they think the facts are in this case. The only time you'll be able to hear about this specific case is if you are selected on the jury, or if you are not selected on the jury and you decide to stay with us because you want to hear the case. So that is the only time. So whenever you hear a question by the state's attorney or by the defense, remember, it's a hypothetical. Does everyone understand?
Yes.
Now, the way cases come to a criminal court for trial is a case is indicted. An indictment is not evidence of guilt. It is not to be considered as that. It is not to be considered for anything, really. It's just a means by which a case is brought to court. How many people here have had a traffic ticket before? Oh, remember, raise your cards. Look, we're practicing. Oh, there are some people who've had no traffic tickets, or either, I think the statute of limitations may have ran. So if you've had a traffic ticket, you can actually raise your card. So whenever you get a traffic ticket, and I've had one in my younger days, I'm 22 now, so I had it when I was 21. Okay, there should not be that much laughter. You're supposed to say, oh my gosh, she's so young. But I had one when I was younger, and that was at the time when they had the ticket book. Now I think they do electronically or something. Mm-hmm. So when an officer pulls you over, let's say they say you did a rolling stop at a stop sign, or you sped through a school zone, which people are doing. School zones are out there. Please do not speed in the school zone. But let's just say an officer says that you didn't stop at a stop sign, that you rolled through the stop sign, or you didn't even do a rolling stop. You just went through the stop sign, and they give you a ticket, and you accept that ticket. On that ticket, it will tell you what the officer is accusing you of and where you need to be to respond to that. So when you accept that ticket from that officer, you're not saying, yes, I agree with you. I did not stop at the stop sign, or I did a rolling stop. You are accepting that ticket so you'll know what you're being accused of and where you need to appear. Does everyone understand?
Yes.
So an indictment is the same thing. You're not saying I did anything or that I'm guilty of anything. That indictment is to let you know what you're being accused of and where you need to appear. So is there anyone here who's going to hold it against Mr. Jones because there has been an indictment that's been filed?
No.
Okay. Now, the next thing I want to talk to you is some constitutional rights that all of us have when we're accused of an offense in a criminal case. You have the right to remain silent. Has everyone heard of that? Is there anyone who has not heard of that? Because that was a low sound. Anybody watch Barnaby Jones? Beretta Maddox. Thank you, number 29. We've seen a lot of life. The young people don't know about that. Paper Chase, The Practice, all of those shows talk about the right to remain silent. So what does that mean? That means that, one, you do not have to give testimony against yourself in criminal cases. Does everyone understand?
Yes.
Now, there are many reasons why people don't want to testify in a case. I've been a defense attorney, I've been a prosecutor. Sometimes people who are accused don't want to testify because their attorneys tell them, you don't need to testify. State didn't prove their case. Sometimes people are shy. because believe it or not, it's hard to sit on a witness stand and everybody's staring at you. Sometimes people may have speech impediments. There are a whole host of reasons why somebody may not want to testify. But here's the key point in criminal trials. You are not allowed to hold it against someone for not testifying. You cannot be Mrs. Kravitz from Bewitched saying, I want to know what they would have said. And I wonder, well, why didn't they do this? Why didn't they do that? You are not allowed to do that. You're not allowed to consider it all. Does everyone understand?
Yes.
Is there anyone who will hold it against Mr. Jones if he decides not to testify?
No.
Okay. Now, the next thing I want to talk to you is the concept of everyone is presumed to be innocent. So when you are accused of an offense on the criminal side in a court of law, you're presumed to be innocent unless and until the state proves their case. And the burden of proof is proof beyond a reasonable doubt. And that means that they have to prove every element beyond a reasonable doubt. Now, when I graduated from law school, everyone had to know the definition of proof beyond a reasonable doubt. I knew it backwards and forwards. I was so proud of myself. The very first jury trial I had, which was, 26 or so years ago, I said the definition, I didn't stumble. I paused where the comma would go, and I was so proud of myself. Then the next time I had a jury trial, guess what? The powers that be said there is no longer a definition for proof beyond a reasonable doubt. So neither the state or the defense can give you a definition of proof beyond a reasonable doubt because there is no definition anymore. So how would I would explain it to jurors after that point is by telling them what it's not, because I always wanted to make sure that jurors were not applying a burden of proof that's not the burden of proof for a criminal case. Next door, you have the beautiful historic courthouse, the one with the green rooftop. They try civil cases over there. So your car crashes, many cases involving money. Those cases, the burden of proof is preponderance of the evidence, more likely than not. Proof beyond a reasonable doubt is not more likely than not. It's a higher burden than that. So if ever you're deliberating and you're thinking, well, more likely than not something happened, you know you're not using the correct burden. Does everyone understand? The other burden that they have on the civil side is clear and convincing evidence. Clear and convincing evidence is the burden of proof that is used to terminate someone's parental rights. So that means that someone is saying, you're not a good parent, you're a danger to your children, and you can no longer be a parent. That's the burden that's used to terminate parental rights. Does everyone understand?
Yes.
That burden is lower than the burden in a criminal court. In a criminal court, the burden of proof is proof beyond a reasonable doubt. Does everyone understand? And that is the highest burden we have. And I recognize that sound. Somebody's doing a video call or requesting a video call. Oh, no need to apologize. My niece she's a year and I think 5 months, she's always doing video calls with me. So I understand. Is that something you need to answer? Okay. All right. Now, the next thing I want to talk to you about is phases of a trial. On the criminal side, there are 2 phases to a trial. The first phase, people always like to say, oh, it's the innocence phase, but that's not what it is. The first phase of any criminal trial is either a person is guilty or not guilty. It's not a person is innocent. So that's phase 1. Phase 2 is called punishment. There is no punishment phase, of course, if someone is found not guilty. According to our law, everyone who is going to a criminal trial must make an election or select if they were found guilty, who would decide punishment? Some people say, I want the jury to punish me if I'm found guilty. Some people say, I want the court to punish me if I'm found guilty. The law is that anyone who's accused of a criminal offense and they're going to a jury trial, they have to make that selection. They're making that selection or election is not an evidence of guilt. It's just something that's required. Does everyone understand?
Yes.
And is anyone going to hold it against Mr. Jones for making an election on punishment?
No.
In this case, Mr. Jones has decided if he were found guilty that he would come to the court for punishment. Is there anyone here who's going to hold it against him that he's decided if he were found guilty, he would come to the court for punishment? Okay. Next, I want to talk to you about languages. I love languages. I think languages are so beautiful. When I went to undergrad, grad school, and then to law school, I was surrounded by so many people who spoke so many different languages. I'm originally from Louisiana. So take a wild guess where I thought I was going to be and what language I decided to take in junior high. I know now it's called middle school, but I decided to take the language of French. My friend Tanya said, Stephanie, we should be in class together. You should take Spanish. I'm like, I'm not going to need Spanish. Taking French. So I look back on that and I'm like, maybe I should have taken Spanish. So I am slowly learning. The deputies and everyone who speaks it are trying to help me. The only thing I know is really how to say hurry up in every language, because that's all they could teach me. So with that being said, these proceedings are going to be in English. Is there anyone here where English is not your first language? If it isn't, if you could raise your card for me. Oh, okay, because I was going to say that is shocking because usually we have some people. Okay, when I call your number, please lower your card. 1213, the person your card is turned backwards. 32, 44, 63, and 69. All right, guys, remember my instructions about who should stand when they speak? I'm giving you guys a hint, so don't disappoint me. Juror number 12. What is your first language?
Spanish.
All right. Have you been able to understand everything?
Fluently.
I'm sorry?
Fluently.
All right. Thank you. Number 13. And your first language?
That's a Spanish.
All right. Have you been able to understand everything?
Um,
All right. How long have you been here in the country?
like 30 years.
30 years. Did you go to school here?
No.
Oh, where did you go to school? I'm interested now.
No time to go.
Oh, okay.
I just have time to work at that pretty much.
Okay, awesome. And so where are you from originally?
From Michoacán in Mexico.
All right, thank you. I always ask people where they're from because these are places that I can put on my bucket list to visit. All right, juror number 32. Yes. What's your language?
Spanish.
All right, have you been able to understand everything?
Everything, ma'am.
All right, thank you. Number 44. What's your language? All right, so that's the person with the throat issue. Yeah, awesome. Have you been able to understand everything? I'm sorry? 70%. Okay, that's a C. That's passing, as my friends in school would say. All right, thank you. Although some of my classmates would say D is for done. I'm like, what? All right, 63. Yes. Thank you so much. See, this is why we did this. And where are you from? Ah, so if I go there, where should I go?
Well, you got
Okay. All right, thank you so much. Oh, I'm sorry. Have you been able to understand everything? All right, thank you. See, that's why I took French. Number 11.
I apologize. Technically, first language was Spanish.
Okay, and have you been able to understand everything?
Absolutely.
All right, thank you. Number 69. Yes. And have you been able to understand everything? All right, thank you so much. I will tell you, usually we always have someone who has a different language, has been from somewhere else. And I always think it's exciting when you meet somebody who's from somewhere else and you get a chance to know where you should travel. So now I know if I'm going to the Congo, I need to check with the embassy first. So that saves me. All right, so I want to talk to you about travel arrangements. Is there anyone who has any type of time constraints or any travel arrangements that are coming up where you book your tickets and you can't put it in my name? All right, just raise your card if that's the case. All right, 10, 18, 34, 37, 8, 12. All right, let me do this. When I call your number, just lower your card. 8, 10, 12, 18, 34, 35, 37, 38, 46, 48, 49, 51, 61, and 66. All right, number 8, what is your time constraint?
My daughter will be graduating in Pecos, Texas next Friday.
Next Friday?
Yes, ma'am.
Oh, what is she studying?
She's graduating from high school.
Oh, that is so awesome. So what is she planning on doing?
She doesn't know just yet. She was born legally blind. So at the moment, she will be heading to Austin to the School for the Blind.
That is so awesome. Tell her I said congratulations. So that means that you will be leaving on the, are you leaving on the 26th or?
In the day before, yes, ma'am.
So you'll be leaving on the 25th. Well, tell her I said congratulations.
Thank you.
All right. Number 10.
I have a road trip to New Mexico with my boyfriend from May 22nd to 26th.
Have you, is it road trip? Are you all on a motorcycle or what?
In his car.
Okay.
I have an Airbnb booked already.
All right. So in his car, have you all had the oil and everything checked? These are questions my mom would ask.
Ready?
All right. So you're leaving on May 22nd?
Yes.
All right. Well, happy travels.
Thank you.
Number 12.
Yes, I have clients that are leaving and I have a construction project with their house. So.
All right. And when is this construction project?
When it's started at the beginning of this week and I need to be done by Friday.
And where are your clients going?
That, I don't know.
Well, I mean, it makes a difference if they're just going to the HEB.
No.
No, okay.
From what I understand is they're on vacation, sir.
Okay.
If I need to gather that information, I probably could.
All right. And so you say that you need to have this project done by Friday?
Yeah,
So that's the 19th?
correct.
Okay. All right, juror number 18.
I have a weekend getaway plan this weekend. I leave on Friday
All right, you're leaving Friday. Where are you going?
to Dallas.
Okay, Dallas is your weekend getaway. What are you going to be doing in Dallas?
I have a friend in WNBA. She has a season opener on Saturday. So
Okay. Awesome. Thank you. Number 34.
I'm leaving on June 2nd with my cruise.
June 2nd to when?
To a cruise. It's a week cruise and then the following week, then I leave for Vegas for work.
All right. So the cruise, where are you headed?
To the Bahamas.
All right. People here may say, don't allow her to go. And then after that, you're doing
And then I've got a week in Vegas for work.
for work.
Yes.
Do I need to have you sworn in? Okay. All right. Thank you. Number 35.
I have a flight on 12th of this month. I'll return the 21st of this month. I would return the 12th of June.
So May 21st through June 12th. Where are you headed?
just to, my second home in Georgia,
Okay. What part of Georgia?
Simon's Island.
Ah,
Golden
so are you from Georgia?
No, I'm from Oklahoma.
All right, because I was,
I have a house.
all right, because I was saying, I don't hear that accent. And as somebody from Louisiana, I'm like, okay, thank you. Number 37. Yes.
I'm a veterinarian and I have surgeries planned for next week, starting on the 22nd.
Okay, so starting May 22nd, you have surgeries. All right, thank you. Number 38.
Doctor's appointment tomorrow.
Number 46.
I have a road trip for June 10th. I'll be back the first week of July,
Where are you headed?
California.
How are you traveling?
Car.
Car. Nobody wants to do the motorcycle.
I'll get the oil change.
All right. Well, I know you will, but so you're not traveling with them. Okay. All right. Well, safe travels. And that's starting June 10th, correct?
Yes.
All right. Number 48.
I'm traveling to Greenville, Texas, a week from today to take care of my dad post-surgery.
Okay. And I'm sorry, what date?
Week from today, so the 24th, and I'll be gone for 2.5 weeks.
All right. Thank you. Well, let me ask you this. What I'm used to parishes. What county is Greenville? Oh, I just gave her a geography test. I said, I just gave you a geography.
Yeah, really, I'm not good at geography.
Oh, okay. All right. Thank you. 49.
Yeah, I'll be on military orders starting June 1st.
Oh, thank you for your service. All right, 51. All right. And what time is your jury trial? I'm sorry, what somebody texted. No. It's another judge just texted me about their jury trial. So what time is your daughter's dental appointment? Is this for braces or something? Ah. And then on June 18th, that's when you're leaving? Okay. All right. Thank you so much. Number 61. Yes.
I have a plane ticket for June 20th through the 27th.
And where are you going? Don't say Georgia. Oh, Hawaii. Oh, congratulations. Are you? Oh, wow. That's awesome. Congratulations. Number 66.
Ma'am, I verbally accepted the job at PC and my started date is in August.
Oh, I don't think we're going to be here till August. I could be wrong. All right. Thank you. 75.
Training for my job, same training on Friday.
All right. What time?
4:30. And then I have also, I work in Gerald for a company in Gerald, so I have to be back in Gerald on Tuesday of next week.
Okay.
And I travel from Nashville.
Okay. All right. And what's your job? Ah, limestone. This is the city to be here for the limestone. All right. Anyone else? Now people are not shy now because they're like, nothing happened to anyone when they told. All right, number 19.
Yeah, I'm a travel nurse. I accepted a contract starting on the 1st of May that goes through the 1st of July. And I'm in Brownwood, which I had to drive from.
Wait,
today.
May 1st?
Yeah.
I mean, are you leaving somewhere May 1st? Because we're already in the 17th.
This,
Okay.
but I'm up there from the time I check in until the contract is finished.
All right. And so when do you need to be there?
Friday, I'm on the schedule again.
Okay. All right, thank you. Anyone else? Number 52.
My child has physical therapy twice a week.
Okay. All right, thank you. Anyone else? All right. So I am going to have you all be released for lunch, but before I release you for lunch, I'm going to tell you two stories. Right? The first one is about my uncle. And I always tell this story because I realize that for some people, jury duty is an inconvenience. And I say inconvenience because you have to put things in perspective. Because for some reason, every downtown you go to, they have one-ways. And you get a little frustrated when you're not downtown on a regular basis because you're just like, if they would just let me turn right, the building is right there, I could be right there, and you have to go around. But the story I'm going to tell you is about my uncle. My uncle and my mom and their siblings grew up in a place called Grand Cane, Louisiana. It's a small, small town, and it's gotten even smaller with its population. So he was super intelligent. And the teachers would move him up a grade, up a grade, up a grade. Now, when my mom and her siblings would go to school, because everybody knew everybody, they would say, we're expecting a lot because we know your brother. So my my uncle ends up graduating from high school. And when he graduates from high school, he graduates early, of course, and the Vietnam War breaks out. So he's my grandmother's firstborn. And he tells my grandmother, I'm just going to sign up to go to Vietnam because everybody's being drafted in Grand Cane. Anyway, they're drafting all of the boys in Grand Cane. I'm just going to sign up and I'll be able to improve my situation in life by going into the military. So for me, that's a big sacrifice because my grandmother had to sign to send her firstborn off to war. And it's not like now where you can email somebody. You know, you had what they call the snail mail. You don't know what's going on. And so she had to sign up for him because he was too young. So for me, that's a sacrifice. This is just an inconvenience for some. And he came back from Vietnam. He's since passed, but I always tell everybody that story because here in the United States, your country doesn't ask a lot of you. You have to pay your taxes and they ask for you to do jury duty. That's all they ask. They don't even ask for you to vote, which I think everybody should vote, but they don't even ask you to do that. They just want you to take this small amount of time out of your life to come and serve on a jury. That's all the government is asking for you. So it may be an inconvenience, but it's not a sacrifice. And what I can tell you is both the state and the defense, and in this case, Mr. Jones, want people to have open minds to listen to whatever evidence is presented, because even though coming down here may have been an inconvenience for the parties who are involved in a jury trial, it is one of the most important things in their life at this point in time. So I always want jurors to make sure that at this time, if you're on the jury panel, it is the most important thing to you and everybody to be focused. The other story I want to tell you is about one of my friends that I went to law school with. She decided that she was going to do civil law. I always wanted to do criminal law. It's always been my passion. And she said she had jury duty. And she's like, let's do lunch. I'm like, yeah, let's do lunch. We hadn't done lunch in a while because on the civil side, usually you work in the office, you never come to court. So we have lunch and I ask her, how is jury duty going? And she tells me it's going fabulous. Looking back on that, I even find it more hard to believe because she wasn't in my court. So how could it be fabulous, right? And I said, why are you saying that? She's like, I'm not going to be on the jury. I'm like, why do you say that? She said, because it's just like law school. Got my head down. I'm not speaking up. And so I started laughing and she's like, what's so funny? I said, we're going to have lunch all week. And so 5 o'clock rolls around and I see her. I said, so how's it going? She's like, we're going to have lunch all week. I'm like, well, that's a fabulous thing. So I tell you that to say how you end up on this jury is you're quiet. Otherwise, you raise your hand with lights and you say, please pick me. I desperately want to be on this jury. And so I tell you that story as well, which is true, because both the state and the defense are going to want to hear from each of you so they can know what's going on, so that you'll know what's going on. So please do not be shy in answering questions. I'm going to release you from lunch, but before I release you from lunch, you've all had a chance to hear, hopefully, each of you speak. So other than meeting downstairs in the central jury room or standing out in the hallway, do any of you know each other? All right, see, there's one person. Could you raise your card? There's one person. If nobody else raises their card, she's going to be like, what? I know them. So 43, 21, 61, and 73. All right, 43, who do you know? Oh, and you know what? Your niece was slow to raise her card. You need to talk to her about that. All right, who's number 43's niece? All right, who is that? Number 57. All right, is there number 43? Remember, is there a reason why your niece wouldn't raise her card right away? Oh my gosh. Are you all going to have lunch together later today? You need to talk to her and then call her mom.
I know.
Okay. Number 21, who do you know?
I have a coworker that works with me.
Oh, who's your coworker that may or may not have raised their card? All right, 73. Oh, she did raise her card, so she knows you. Then we have 61. Who do you know?
Number 12 recognizes me. I was in Humble Bay with Thurman and.
What?
Okay, so we're gonna give him a pass because you were wearing the mask, but it immediately clicked with him.
Yeah.
All right, 57, who do you know? 57, raise their hand, right? Yes. Wait a minute, you have two nieces here? Oh, it's the same. Oh, now she's claiming you. Okay. All right, is there anyone else? Number 36.
Yes, ma'am. I don't know anybody here, but I thought we were only talking about travel alibis for next week, so I have one for Monday.
Oh, there's no alibi, but okay. Number 36, where are you going?
My wife has surgery on Monday.
Okay. All right. Well, I know everything is going to go well.
Yes.
Okay. All right, everyone. So does everyone remember which court you're in?
187, Stephanie Boyd.
Thank you. All right. So what I'm going to do is I'm going to give you all a break for lunch. Please do not overeat because then people end up getting sleepy after lunch. But I always like to make sure that the court reporter gets her break because even though we're seeing you all at this time, we've actually been in court since 9 this morning. And so she's been taking down a record. And if you can imagine, when you're constantly going, sometimes you need a break. I don't want her to get carpal tunnel syndrome or something. So we're going to take a break. We're going to have you all back here at 1:15 lined up. So everybody, if you look to your left, look to your right. You are responsible for the person who's sitting next to you. So when you all line up outside, nobody should have a person that's missing. Does everyone understand? Yeah. All right. So if you'll leave your cards behind, but do not come in, just remain outside. All right. Everyone, please rise.